Hello, everyone, and welcome to the session on evolution of corporate governance. This is a session which we are going in continuation with our class on corporate governance in the honors program. Today's session, we will try to focus upon how corporate governance as a concept has evolved and what is the present status of this concept for all of us. And that is the idea and objective of today's session. So I have a structured presentation. I will take the questions towards the end and feel free to ask me any questions you have when I open the floor for questions. In the meantime, you can use the chat box for asking any questions there. So chat box is open. You can just put your questions there. Now, moving forward, if we look at the concept of corporate governance, as already discussed in the class, actually began with an idea in UK, United Kingdom, by Sir Adrian Cadbury, which or the photo of whom you are able to see here. So, but it was not the situation that before Adrian Cadbury or this discussion in UK, there was no corporate governance in the world. We have already seen that there was corporate governance, and in fact, the establishment of joint stock companies itself highlights the fact that there is some governance mechanism in the companies, and those governance mechanisms were very much there. But that was not very detailed mechanism, or it was not specifically being mentioned that this is the mechanism available for corporate governance. So the first time a formalized concept of corporate governance came by way of Cadbury report in UK, and Cadbury defined the corporate governance as the system by which companies are directed and controlled. So this is what the definition Cadbury gave, and his report talks about all this system. What are the major elements of corporate governance, how corporate governance happens, and what all things needs to be taken into consideration to take care of the corporate governance regime. Now, if you will see, there are further definitions of corporate governance which have been provided in different bodies and different scholars. One of the definitions which I prefer is OECD, and OECD is group of developed countries, and they have come up with a definition of corporate governance which is quite elaborate. And if you read that definition, it says corporate governance involves a set of relationships between a company's management and its board, its shareholders, and other stakeholders. So these all stakeholders relationship, how it will be managed, who will be having the accountability, who will be having the responsibility is taken care of by the corporate governance. Corporate governance also provides the structure through which the objectives of the company are set and the means of attaining those objectives and monitoring performance and determined. So it is not only about the structure, but how that structure is performing or how that structure is working is also a very important element in the definition of corporate governance. And this is something which is being provided by OECD definition. Now, if you look at the evolution, as I told you before, it was the Cadbury Committee report through which it all, began with. And the report which came up by Cadbury was referred to as Financial Aspects of Corporate Governance Committee. And I have provided a link of this to you people and I hope you are able to see this particular document when it opens. And if you see this document, this is what the corporate governance report is all about, the financial aspects of corporate governance. And this committee's report talked about many things, like, for example, the code of best practices, the board, the internal controls, audit committee, directors, what will happen to the insider trading by directors, directors' responsibilities, so financial aspects like auditing, and then what happens to the accountability of board of shareholders, of accountability of board towards shareholders, institutional shareholders, and various communication which requires to be done in this situation. So a 90-page report gives that concept and clarity. So objective of this report was to set into context the various corporate governance requirements. And that is what exactly happened in by way of this report. This report was triggered again, as I told you, that a lot of corporate governance developments have happened because of the corporate frauds or different misdemeanors in the financial system, and that has triggered some committee or some mechanism which was required to come up with a report. And this specific report of Cadbury committee was triggered by a series of corporate scams and collapse which has happened in the banking system in United Kingdom, whether you talk about Polypack, whether you talk about Bank of Credit and Commerce or International, that is BCCI, etc. These were different scams happening at that point in time. Probably that was the period 1992 when liberalization was coming up. There were multiple scams happening across the world, and that has triggered a lot of reforms in the regulatory landscape. If you look at India also, SEBI came up during that particular period, and there were a number of reforms which has happened during that period in UK, USA, and all other places. So in 1991, London Stock Exchange appointed a committee under the chairmanship of Sir Adrian Cadbury, and he submitted a report. That report is referred to as Report with Code of Best Practices, which I showed you just now. And this report basically required certain listed companies to report its compliance and explain if they are not able to report that. So it was basically the regime was comply or explain. So if you are not complying with that, then you give an explanation why you are not complying with that. What is the reason why you are not providing that particular data or information? So here the focus was on directors, and it was said that directors should report on the effectiveness of a company's system of internal control, and they should try to make sure that the company's internal controls are strong enough to take care of any fraudulent activities or any other activities which are there. However, if you will see, there was a committee which looked at this report of Cadbury, and they were of a view that the provisions are a bit harsh. There is a lot of pressure on the boards and the private companies, and this required a bit of a relaxation kind of a thing, and that is where the Paul Ruthman committee said that let us not enforce too much of this internal control. Then what happens is the flexibility of the company in operation and working goes away. And that is the reason you will see that there is more flexibility of operation to private companies than public companies. Public companies are having less amount of flexibility than the private companies. But yeah, there is also a very important thing that public companies have a lot of public money also, and hence they need to be more accountable than a private company. And that is why this check and balance is very, very important. So Cadbury Committee actually set the tone for corporate governance reforms across the world. And from there, most of the countries started picking up the idea that they need to have some amount of corporate governance in their system. And generally, this system of corporate governance was rooted at the stock exchanges, or you can say the securities regulator, which is different regulators for different countries. For us, it is Securities Exchange Board of India. And for UK, there is a Financial Council. In USA, there is a Securities Exchange Commission. Like that, every country has got a securities regulator, and most of the corporate governance norms are being taken care of or dealt with by the securities regulator. And the responsibilities of implementation of these lies with the stock exchanges, and that is done by way of rules and regulations. So this is how the corporate governance system started with the Cadbury Committee report. Subsequent to the Cadbury Committee report, the things were not just settled at that point in time. There was further committees which came up, and they gave different documents, and these documents were one document by Greenbury Committee in 1995, and they specifically focused on the director's remuneration as to how much a director's remuneration could be, what should be the parameter of fixing that, what should be the accountability of directors. These were the things which were talked about in 1995. If you look at the Greenbury Committee report, this is also a detailed report, and It talks about a director's remuneration, as you are able to see in this picture. Report of study group chaired by Sir Richard Greenberry. It was 1995, and they talked about the code of best practices and how the remuneration committee should function, what should be the remuneration policy, service contracts and compensation, and if there are utilities which are privatized. So when we talk about utilities, these are public utilities. Either you talk about the bus services, railways, or airports. These are all public utilities, waterways. So this is where they wanted that there should be proper governance. Otherwise, the things will fall apart. Then there was another committee which came up in 1998 that is called Hampel Committee, and this report assessed the impact of Cadbury Committee and recommended progressive guidelines. So the Hampel Committee report, basically told about that basically reviewed the work of the Cadbury Committee and further recommended many practices which were required to be looked at by the corporate governance, and that is where they came up with a UK corporate governance code. They merged everything, that is the director's remuneration and the remaining one they brought up as a combined code, and that was referred to as the corporate governance code in the United Kingdom. And both the aforesaid reports basically constituted the combined code, which now is appended to the listing rules of London Stock Exchange, and the compliance is made mandatory for all the listed companies in the London Stock Exchange. There was another, in 1999, there was another guidance which was given towards risk management, another important area of corporate governance, and this was called as the Turnbull guidance. And there they required the board to confirm that there was an ongoing process of identifying, evaluating, and managing key business risks. And the system of establishing internal control was very much emphasized in this report and was applicable for listed companies. So this is how the corporate governance shaped in the United Kingdom. Why we are referring to United Kingdom? Because our company law takes a lot of precedence from there, and our stock market and our laws look at that, and that was basically a formed up corporate governance regime. So we wanted to learn from that and come up with our own regime. This is how we moved further with this. There is another parallelly, if you will look at it, there is sectoral governance also. Like for example, in banking sector, if you have a look at it on corporate governance, there is a Basel Committee recommendations which recommends the corporate governance norms for the banking sector, and the banks are required to be following certain norms as far as their functioning is concerned, and that is dealt with by Basel Committee. Though banking companies are subject to the general corporate governance norms, and special corporate governance norms also are under the sectoral regulators. If you see the present day corporate governance framework, the UK Corporate Governance Code of 2024 gives the present day framework of corporate governance, and that is by way of board leadership and company purpose, division of responsibilities, composition, succession and evaluation, audit, risk and internal control, and remuneration. These are the 5 major items on which the corporate governance framework of UK rests. And this is the latest regulation, and I would suggest that at least you skim through these particular regulation for understanding as to what they are telling. Let us also look at the developments in the United States, and much prior to 1992 development of Cadbury Committee report, there were developments which has happened in United States, whether you talk about the 1970s or 80s. This was the period when they were speaking about corporate governance. American Law Institute, American Bar Association, these bodies have been talking about, but that efforts did not take a lot of limelight than the UK regime, because UK regime was much structured and they had a code which need to be followed. In US, the corporate regime is a bit scattered because there are 50 states, and all these 50 states are having their different company legislation, and it works in that way. So if you go to one US state to another US state, the company law differs, and that is why they don't have a uniform corporate governance regime as you would see in case of other, places. So a much impacted focus of corporate governance happened by way of Sarbanes-Oxley Act in July 2002. And this happened again, the reason was a scam. So in US, there was Enron, which happened, and Enron was a big scam which happened. And as a result of several corporate frauds, including Enron, there was a requirement of having some measures in place to take care of the financial frauds and issues. And that is where the Sarbanes-Oxley Act, or it is also in popularly referred to as SOX, and they came up with a detailed regulation. However, if you go back into the history, you will see that the Watergate scandal, which was basically dealing with the political contribution during the Nixon's presidency election, or you can say lobbying activities, was a huge thing at that point in time. In India, if you have a comparable situation, was the electoral bonds scheme case, where these issues were brought up, that how much a company can be contributing towards the political contribution. Again, a very interesting area to look for. So the Securities Exchange Commission proposed some mandatory reporting requirement and internal financial control. In 1987, the Treadway Commission highlighted the need for control environment, independent audit committee, and objective internal audit system in the US system. And the Committee of Sponsoring Organization report in 1992 stipulated control framework for orderly functioning of corporations. And there were other committee reports like Blue Ribbon Committee, which talked about improving effectiveness of Corporate Audit Committee, Dodd-Frank, Wall Street Reform, and Consumer Protection Act. These were the different legislations in United States, which, after the financial crisis of 2008, recommended certain measures for having corporate governance or strong corporate governance in United States. These are some of the framework under the COSO framework. As we discussed, there are 6 elements to this. This has been discussed already. So I just skip this for your information. You can go through these principles. These are the core of the corporate governance norms. Now, in the international framework, these US and UK, these are the 2 regimes. Other than US and UK, there are multiple other frameworks of corporate governance. Though we are having one session on international corporate governance that we will talk about in detail, but for your understanding, right now you can focus on World Bank on corporate governance. So the World Bank basically wants that the countries with which they are, working with, or they are giving a funding to, their companies should be having a proper corporate governance. Otherwise, they will not fund it. And hence, the Financial Market Integrity Group in the World Bank is basically providing for the global best practices in the corporate governance and require certain mandate for the companies to be followed. And the group works basically closely with the corporate governance group of IFC and interacts closely with other World Bank group global practices such as trade and competitiveness, governance, macro fiscal management. So this provides a cumulative framework internationally for promoting corporate governance requirements. If you see, the focus of World Bank corporate governance is on financial sector and capital markets. Naturally so, because any effect in one market of financial market or capital market has a huge amount of impact on the world market. So hence it is very important to manage certain things. There is also International Corporate Governance Network. This is just for your information. You can have a look at it. This body is a virtual body where the international convergence is tried to be drawn, that okay, fine, these are certain measures which has to be common to all the countries, and the countries keep deliberating upon different issues. Like, for example, what should be the rights and responsibilities of an independent director is being dealt with by under this particular regime. So this is a thing which you have to have a look at. Then there is OECD on corporate governance, for which I have already talked to you, but you can follow certain literature there. There is a lot of literature available on OECD website on corporate governance, including the OECD principles of corporate governance, which we will discuss in a separate session altogether. So we will see what it is trying to tell about that. Now let us come back to India and try to see in India how the things has started. So you would be surprised to know that in India the corporate governance thing did not start actually with the government, but with a private industry body, that is Confederation of Indian Industry. And Confederation of Indian Industry appointed a committee or a national task force in 1996 under the chairmanship of Rahul Bajaj. You must be knowing Bajaj company. Everybody knows it is an automotive company. Its chairperson Rahul Bajaj was the national task force head. And under his leadership, they came up with Code for Desirable Corporate Governance in March 1998. And this was discussed in the industry body, and there were 17 recommendations which were given by this committee, that is Confederation of Indian Industries. And they wanted to integrate these things with world market, because you can see parallelly there were developments happening in UK, US, and hence the Indian industry wanted that if you really want to perform better, if you want to compete in the international market, you need to have some governance principles and some approach with you. And that is where they gave basic principles of corporate governance. And they said that everything cannot be legislated at, detailed mechanism. There has to be principle based approach, and they should have some basic principles laid down there. And that needs to be followed by different companies. This is something which it was informed. Now you can see this voluntary approach, which was recommended by the Confederation of Indian Industries, actually took a mandatory approach later because of multiple scams which has happened. And in 2009, there was a Satyam scam which happened. And then the corporate governance recommendation for voluntary adoption by Naresh Chandra committee or other committee reports were re-looked at. And it was said that, see, you cannot have only a voluntary requirement. You need to focus on the mandatory aspect of it as well. And CII later on also came up with model code of conduct or ethical business practices for the business houses. So this is the approach of a industry body. Similar to Confederation of Indian Industry, there are other bodies like FICCI Chamber of Commerce, ASSOCHAM. There are multiple bodies which keep on discussing corporate governance, or you can say Institute of Directors. These bodies are able to discuss the various approaches or various dimensions of corporate governance. Now, if I take you to the SEBI initiatives, by this time, the SEBI had already come into existence, and now SEBI came up with an idea, and this was the SEBI initiative first, which they came up in 1999, is the Kumar Mangalam Birla Committee report. So the Kumar Mangalam Birla, you all know, Birla is a company and its chairperson was Kumar Mangalam Birla. And he was appointed as the chairperson on behalf of SEBI, and other members were there. And they came up with a detailed report on corporate governance. And this report mentioned many things. So this is the report which you are able to see, and it gave number of recommendation in for corporate governance. I urge you to go through this particular report briefly. You will see that there are different things which they have mentioned, like, for example, powers of audit committee, functions of audit committee, what is the board of directors, how they should go, how remuneration should be done. Here, I would also highlight certain things, that there are mandatory and non-mandatory recommendations. So in each of these committees, which were constituted by SEBI or Ministry of Corporate Affairs, there was a recommendation which was given as mandatory recommendation, and there were recommendations which were given as non-mandatory recommendation. So they said that there are certain things which are non-compromisable at that point in time, and you need to follow it through. Like, for example, board of directors, having proper audit committee, remuneration of directors, board procedures, management, dealing with shareholders, report on corporate governance were mandatory recommendation by Kumar Mangalam Birla Committee report. And the requirement of having an independent chairman of the board was a non-mandatory recommendation, and it was voluntary on the company to have a chairman of the board which is independent director or an independent person. Similarly, to whether to have a remuneration committee or not was a non-mandatory recommendation by Kumar Mangalam Birla Committee report. However, you will see subsequently when Naresh Chandra committee report came up, this remuneration committee has now become a mandatory recommendation. So you can see the progress. In the initial years, the things which were voluntary over the years have been made mandatory, because you cannot impose very, very strict regulation immediately. And this concept in management is referred to as priming. So you are trying to basically, prime the industry and tell them that, okay, going forward, we are going to have strict norms. So start practicing it. And that is what they have done. Like, for example, this postal ballot was a non-mandatory recommendation, which has now become a mandatory recommendation under the present regime. So this is how the corporate governance recommendations were given by Kumar Mangalam Birla committee report. And at this juncture, there was an introduction of clause 49 of the listing agreement. And if you are prior to 2013, if you read about corporate governance, you will find not 2013, 2015, if you read, you will find clause 49 was a synonym to corporate governance. So clause 49 of the listing agreement was basically a clause which provided for all corporate governance norms under the listing agreement. So what is a listing agreement? Listing agreement is an agreement between the company and the stock exchange to list the shares for trading. And that document requires certain obligations to be followed by the companies. And this is what was referred to in clause 49. So corporate governance prior to 2015 was clause 49 of the listing agreement. After 2015, the SEBI came up with a regulation on listing obligation and disclosure requirements. And that document now is a corporate governance document. And there is no need for an elaborate listing agreement. There is a small listing agreement. However, the corporate governance norms are there in the regulation. This provides a uniformity for all stock exchanges. These are the two logos which you are able to see of SEBI. This is an old logo. This is the latest logo of SEBI, which they have come up. And there is more clarity, as you can see in the logo. The new logo provides more clarity. Probably they have changed that. Then simultaneously, Ministry of Corporate Affairs also worked on corporate governance. Why Ministry of Corporate Affairs works on corporate governance? Because the administration of company law lies with the Ministry of Corporate Affairs. So the Ministry of Corporate Affairs initiatives are also simultaneously happening under the framework of Companies Act. You have to understand that the SEBI does not regulate all companies. SEBI regulates only the companies which are listed on stock exchange, whereas MCA regulates all companies. And hence, every company must follow some corporate governance norms, and that is being dealt with or introduced by the Ministry of Corporate Affairs. So on 12th of August 2002, the Ministry of Corporate Affairs came up with Naresh Chandra committee report. And this committee report actually provided for a detailed recommendation, and this was 2002. By then, the clause 49 was very much already there. But the Naresh Chandra committee report provided and gave a number of suggestions. And these suggestions, you can see, this is the Naresh Chandra committee report. And they provided for a number of suggestions for private companies, limited liability partnership, Indian Partnership Act. So they had a number of ideas to present and give it to them. And that is Naresh Chandra committee report. And they focused on corporate audit and governance. They talked about representation of independent directors on company's board. They also talked about composition of the audit committee, which should focus on requirements regarding disclosures. They focused on CEO and CFO to certify the company's annual account. That was a mandatory requirement. Setting up of quality review boards at the ICAI and ICSI and ICWAI. So these three professional bodies, they recommended that there should be quality review boards, the CAs, the company secretaries, the chartered accountants, and the cost accountants should be, having a quality review. And they also talked about the major focus of Naresh Chandra was on audit review. If you look at, then there was a SEBI initiative too, which basically was by way of in 2003, after the MCA came up with that report. In 2003, the SEBI nominated a committee that was headed by Narayana Murthy, and that is why this is referred to as Narayana Murthy Committee report. You all must be knowing Narayana Murthy. Mr. Narayana Murthy was the chairperson of the Infosys, a very well run organization, and you are able to see there is a report of the Narayana Murthy Committee, and that is available on the website of SEBI. It is a 43-page report. Again, I request you to have a look at the recommendations which they have made. They considered the recommendation of Naresh Chandra Committee report also, and they have further given a way forward as to what all things needs to be done in the space of corporate governance. So the objective of this report was to review the performance of corporate governance subsequent to Kumar Mangalam Birla Committee report. So you can see Kumar Mangalam Birla Committee 1999, and by 2003, how the corporate governance has performed was reviewed by Narayana Murthy Committee report, and they expressed concurrence with Naresh Chandra Committee report, and they made certain mandatory recommendation on audit committee. They said that related party transactions needs to be informed. What is a related party transaction? Related party transaction is a transaction where any one of the directors is an interested party in that transaction or the meeting. I can give you an example of ICICI Bank and Chanda Kocher's case. That was a related party transaction for which she had to resign, and there was a case also which is going against her. So this is a related party transaction. Then risk management needs to be included, code of conduct needs to be included, and nominee directors. These are the things which were introduced by Narayana Murthy Committee report. And there were certain non-mandatory recommendations, like, for example, the board training should be there, training of boards. Again, I will tell you this non-mandatory recommendation is also made mandatory now under the Kotak Mahindra Committee report. So you are able to see progressively the non-mandatory recommendation of previous reports have become mandatory recommendation for other reports. Then MCA took another initiative, and they came up with a JJ Irani committee. And this JJ Irani Committee report is very famous and very important also because this transformed the company law altogether. And you can see the reform 2013 law is based on the JJ Irani Committee report. There were a number of corporate governance principles which were included in the Companies Act, and recommendations ultimately led to the Companies Act 2013. You are going to have 3 or 4 sessions on interface of Companies Act with corporate governance, and that sessions we will go into the details of the provisions which actually promotes corporate governance from a Companies Act perspective. And then there were cases like Satyam and Sahara, which further contributed to the reforms, and there was a need for multiple changes under the Companies Act, which happened. And in 2013, we got a brand new Companies Act with multiple checks and balances. In fact, the law was too tight, and in couple of years, it has to be reviewed again, and those tight provisions were relaxed later for a simple reason that it became too tight for the companies to function. They require some amount of flexibility, and that flexibility was subsequently granted over the years when they saw that the provisions of corporate governance are now getting implemented properly, so they relaxed them. Under the Companies Act 2013, there were few more authorities which were also established, and corporate governance was made further tightened. Like, for example, there was an authority on IPF, that is in Investor Education Protection Fund Authority was established to deal with the non-paid dividends and any other amount which is lying in the coffers of the company on behalf of the investors need to be deposited back to this authority. And that was one thing which happened. This actually helped with checking with the vanishing companies or companies which were closing down, taking away the money of unclaimed money of people. And then there was National Financial Reporting Authority, which was established under the Companies Act, which dealt with or had a check on the chartered accountants, or you can say was an oversight body on the functioning of auditing functions so that there is no frauds keeps happening. There were a number of frauds which has already happened because of the failures of the auditing. And then the Serious Fraud Investigation Office. These were the 3 bodies which were established under the Companies Act 2013 to check or you can say the promote corporate governance norms in a proper way. And definitely the CSR go into the details of these provisions in subsequent classes. SEBI came up with the another important initiative, and they came up with the regulation, as I was referring to you, that is Securities Exchange Board of India listing obligations and disclosure requirements of 2015, or it is also referred to as SEBI LODR. And this is a primary legislation. You people have to read this for corporate governance. So we are going to go into the details of SEBI LODR one by one provision and understand how corporate governance works. So kindly make it handy. Companies Act, SEBI LODR, these are two legislations which you should do. Other than SEBI LODR, there are ICDR regulation, which is again talking about capital disclosure requirement. This is applicable for IPO. So whenever a company comes up with an IPO, they follow the ICDR regulations they have to follow. And it again talks about multiple disclosures which are there. Then Securities and Exchange Board of India prohibition of insider trading regulation is also there, which requires that the price sensitive data is not shared with people before it is made public. So there is a requirement of handling the price sensitive data properly, and that is what SEBI does in this regulation. So these are some of the additional initiatives, and then came the ultimate report on corporate governance, which is currently into function, and that is Uday Kotak Committee report. And this was 2017. The Uday Kotak Committee came up with 78 broad recommendations on corporate governance, and they came up with multiple suggestions that needs to be implemented. And the Kotak Mahindra Committee report talked about the phased implementation. It is a 176-page report, as you are able to see here. And they have talked about the chapter 1 talks about composition and role of board of directors. And it mentions many things, like there has to be a non-executive director, disclosure and expertise of skill of directors training, etc., etc. And then institution of independent directors, it has focused. Then board committees, which are the different committees, enhanced mentoring of group entities, and promoters controlling stakeholders. So it is a detailed report with multiple recommendations. A number of recommendations were accepted by SEBI, some were not accepted. And that is how this Kotak Mahindra Committee report is a detailed report. You are supposed to go through this report in detail, right? The remaining reports, you can go briefly and prepare some material for it. But for the Uday Kotak Committee report, I want you to go into the details of it, at least see broadly the major recommendations which they have made there. So this was preceded by a consultative paper in 2013 on review of corporate governance reforms by SEBI. And they gave a lot of focus on quality of information. So they said high quality of information represents the basic input for governance, and hence disclosure is very, very important. So if you are giving disclosures, if you are telling everything to people, definitely there is no chance that there can be failure or there can be fraud. But if you are hiding information, then definitely there is a recipe for fraud which can happen. So good governance helps overcome potential agency problem, and regulatory monitoring and optimal use of carrot and stick approach has to be there. So these are the three basic principles on which the Uday Kotak Committee report is based, and that is shaping governance for long-term value creation, shaping governance to protect shareholders' interest, and building regulatory capacity for enhancing governance of listed entities. So this is what three major areas which has been, or major pillars which have been talked about by SEBI, Uday Kotak Committee report, and they have tried to focus on these pillars in its report. By the way, Uday Kotak Committee report is not fully yet implemented. It is being implemented slowly, including the CSR provisions like BRSR recommendations. These are all the things which are getting implemented in a phased manner. There are other reports for investor protection, and these were like NK Mitra Committee report in 2001, which dealt with the banking sector. RBI plays a very important role in instilling corporate governance in the banking sector, and it provides for multiple regulations to take care of disclosure and transparency, prompt corrective action, surveillance, Basel recommendation. This I have already told you. There was another committee in 2001 by Dr. R.H. Patil, which talked about advisory group report on corporate governance. This again dealt with the banking sector. And then there was a committee by A.S. Ganguly, which was again the banking sector. So banking sector corporate governance is another focus area. So corporate governance for the central public sector undertakings is also a specialized area where there are reports which are available. So these two topics, corporate governance for banking sector and the corporate governance for central public sector undertakings, we will deal with it separately in one class each so that you are able to focus on them in a detailed way. So today's class, we wanted to see the journey of corporate governance from the Kotak Mahindra, from the Cadbury report to Kotak Mahindra, and you saw that how the developments have happened from the beginning till end. And now I want you people to have a focused approach towards these topics, and kindly try to go through the topics in detail and at least skim through all the reports except the Kotak Mahindra committee report, which requires a detailed discussion from you people. So that's it. Thank you. I am done with my presentation. Now I open the floor for questions. So you can ask me any questions you have or any clarifications you want to ask or any points which you want to put forward. Floor is open. Yeah. You can unmute yourself and speak if there are any questions. Yes, Pranav. Thank you for that input. I did not see your chat box. It was video case. Yes, very much. Okay. So let me take the attendance then. If you are not having any questions.